forget about the investigations and prosecutions on those cases. We started to challenge that. We started to file writs of mandamus challenging the denial of the police to register FIR and failing to do investigations on the allegations that we were making. There were a number of cases that we made emblematic one to really expose what was really going on, what is really going on, what impunity really means. There were several cases, like as I said, thousands of cases that we had documented, but it was impossible to work in every single case. So we started to choose certain cases as emblematic one to really open the door of justice for many other victims suffering from the similar kind of atrocities. There was a case, I don't know whether you have been following up, the progress in Nepal in terms of addressing some of the human rights violation cases. There was a case back in 2004 where a 15-year-old girl, Dalit girl, was arrested by the military and detained and disappeared. We were following up this case from the day she was arrested because the reason why she was arrested was that her mother was a witness to extrajudicial execution that had happened in the village. At that time, as it used to happen, if any witnesses would speak against any of those cases, witnesses would also be targeted. So we were suspicious that she would be targeted because she had spoken about the case of these extrajudicial executions in the village to the media. So her daughter was arrested and she was not at the home. Military went to look for her. She was not there at her home at that particular time. So they arrested her 15-year-old daughter. And husband was asked to come to the particular barrack when wife comes and take her daughter. So we accompanied her to the barrack, but since then, military started to say that they have not arrested the girl. So she was disappeared. Of course, that was not the true story. There were a lot of evidences that we could produce. There were witnesses to testify that she was arrested by the military. We kept challenging that. So later on, as they were mounting pressure on the military on this particular case, the military came up with a report saying that it was not true that they did not arrest the girl. They did arrest the girl, but when they were taking the girl to the barracks, she attempted to escape from the security forces. So security forces, military was forced to open the live ammunition, and this is how the girl was killed. It was not the true story. We kept challenging that because there were no bodies of that girl where they were saying the incident took place. There were no people to really tell us there were any incidences of such in that particular place where they were saying that the girl was killed. So we kept challenging on that case. And we were also investigating what was really going on, whether we could really verify some of the information that was provided. When we had collected sufficient evidences to establish that girl was taken to a particular detention, and we had enough evidences to establish that, and we started to mobilize pressure. So when there were mounting pressure on military to reveal the truth, they again said that they established the Commission of Inquiry to investigate on this case, and the conclusion of the Commission of Inquiry was that she was brought to that particular detention, but in the morning she was found dead. So they found 3 officers responsible for not observing the proper procedures when they found the girl dead in the cell. Again, that was not the true story, because we had the evidence that that girl was, tortured to death. So the role that lawyers played was not just litigating on the case. What I was trying to say, referring this case, was that from the day one of this arrest to the end of this case, lawyers were involved in terms of establishing the evidences, challenging the false information, the lie that was provided to the family member. So we use some of these cases as emblematic cases to really expose what was really going on and how family members actually experience the conflict and what is the challenges that family members face in terms of accessing justice. So there are a couple of cases of this nature that exposes the extent of impunity that we go through, and we continue to challenge that state of impunity in Nepal. So we brought a number of public interest litigations challenging that state of impunity. For example, the person who was implicated in this case was, for example, promoted. So we kept challenging that promotion. We brought this case demanding criminal investigation. It was not registered. We went to the Supreme Court, had a ruling, not only the ruling against the police to investigate on this case, but the order from the Supreme Court that within particular time frame the case has to be investigated and the prosecutor has to prosecute on this case. As a result of which, this is the first case that could make to the court. Otherwise, in the criminal justice system, the way we function in Nepal, victims don't have direct access to the court. It's the police who has the mandate to do the investigations on criminal cases. They collect all the evidences and they present it to the public prosecutor, and the public prosecutor is the one to prosecute the person or bring the case to the court. Victims don't have direct access to the court. So we are unpacking some of these challenges that we face in this criminal justice system, also filing a lot of public interest litigations and different other things. We have been also started to demand legal framework in terms of addressing some of the atrocities that we experienced in the past, such as in the case of disappearances. One of our colleagues has already presented the case of disappearances and the ruling that Supreme Court had on this particular issue in the morning, so I don't want to go into details of this case, but there was a landmark kind of decision from the Supreme Court of Nepal asking the government of Nepal to enact the legal framework that would criminalize disappearances in Nepal and establish commission of inquiries to look into the issue of disappearances in Nepal with the international standards. And the court also provides that, the elements of that standard as well. We have been also in post-conflict situations, I would say, after 2006. Lawyers are also challenging the jurisdictions of the military court, for example. For example, in the case of Mandira Sharma, one of the issues that came repeatedly, and it keeps coming up, is that there is this principle of double jeopardy. We have already made those, accountable, responsible for the killings of this girl. So, these persons should not be tried again. So, what is the extent and the jurisdictions of the military court? This has been questioned in the court by the public interest litigation that has been filed by some lawyers involved in these cases. Similarly, when those perpetrators were promoted, that has also been challenged in the court. So there are a number of challenges in the court demanding that there is a law or legal framework in terms of vetting of those who are involved in serious human rights violations. So after 2006, there are a lot of litigations, there are a lot of interventions in terms of addressing the problem of impunity, providing justice to the victims, and unpacking some of the problems that our criminal justice system faces. And lawyers continue to intervene in those cases. We have also challenged the jurisdictions of the quasi-judicial bodies, for example, the way chief district officers functions in terms of having powers in dealing with some criminal cases. Our Supreme Court has been very proactive in terms of making rulings and providing some kind of standards and guidelines in some of these cases of human rights violations, in particular torture, extrajudicial killings, and enforced disappearances. As it was already discussed in the morning session, the implementations of the rulings of the Supreme Court, the decisions of the Supreme Court, remains the major challenge. After 2006, as I have been saying, that we are continuously challenging the state of impunity and making justice accessible to the victims who suffer human rights violations in the country. We are also promoting transitional justice mechanisms, but unfortunately these transitional justice mechanisms have been projected as a mechanism to replace the criminal justice system. So we have been continuously challenging that notion of transitional justice mechanism, these provisions of amnesty, reconciliations, mediations in the context of these atrocities committed during the conflict. So these are some of the issues that lawyers are focusing after 2006. We are also trying to use international mechanisms. We have also taken a number of cases to UN Human Rights Committee using the first optional protocol to the ICCPR, to which Nepal is a party. When we exhausted all local remedies and we did not feel that there was justice done on those cases, we have taken those cases to Human Rights Committee of the UN. And there has been a number of decisions from the Human Rights Committee that has helped us to expand the jurisprudence back in the country. We have also explored, and we are successful in bringing the case under the universal jurisdiction. I don't know whether you are aware, one of the serving colonel of Nepal Army from Nepal has been arrested in the UK for his involvement in torture in 2005 in Nepal. So the case which we documented back in 2005 and continuously work on those cases, victims did not have any legal remedies, as torture is not a criminal offense in Nepal and perpetrator enjoyed complete impunity. We continuously worked on that case and explored the possibilities of using universal jurisdictions in providing remedies to this victim. In one of these cases, the UK government, has exercised the universal jurisdictions that it has under its own law by ratifying the Convention Against Torture. So the person has been arrested for 2 counts of torture in Nepal, for which he was accused. He was accused for committing 2 counts of torture in Nepal. The case is still under the jurisdictions of the UK court, so I cannot go into the details of this case. But there is a possibility of exercising the international law, international legal regime, especially the universal jurisdictions in relation to the crimes of torture and war